Shalom, welcome to the Jewish View. My name is Rabbi Nachman Simon with the Chabados of Dalmar, and together with my co-host Mark Roner, just statewide news service, jbiztechphilly.com, and as you can see right here, columnist for the Jewish Press.
Right, I'm having a lot of fun with all three assignments, Rabbi. I have my column in the Jewish Press. It's called Albany Beat, and this is my latest column. It's about the state pay raises that are coming up soon for the administration and the state legislature, possibly coming up. There's a commission that's going to decide. But someone who knows too well about these issues is our guest today, and it's Judge Howard Levine. Thank you very much for coming in and being our guest today. It's wonderful to have you here.
Glad to be here.
So tell us, what is your, do you miss the Court of Appeals? You were judge for about 6 years?
No, I was a judge on the Court of Appeals for exactly 9 1/3 years.
Okay. So
September of 1993.
So do you miss the camaraderie that...
I miss the challenge.
The challenge. Why was it challenging?
Well, it's the court in almost all of its cases selects the cases it wants to hear, and it does that on the basis of the novelty of the issues, the importance of the issues statewide, or because of conflicts among the departments of the appellate division. So virtually all of the cases, both civil and criminal, that come to the court are difficult cases and important cases. That's the challenge.
And you have to split hairs sometimes when you're interpreting what the disagreements are.
Well, sometimes I guess you could call it splitting hairs. Yes.
I mean, because you have to look at a situation and now you have to come prepared as a judge, because I noticed that the attorney might say one sentence and then right away a judge comes in and says, but what about this?
Yeah, that's the way it is. The court has always been what is called a hot bench, means that the cases have been gone over well in advance of the oral argument, and each judge is prepared with the kinds of questions that have occurred to the judges during reading the briefs in advance.
I always felt bad for the attorneys who did all this preparing and they're real nervous up there. Maybe it's their first time before the state's highest court, and all of a sudden they have this big speech that they want to tell you about, and they and they don't get to say it because you come in with, like you said, with this question, and they have to, like all of a sudden switch gears and answer.
Well, the good appellate advocates enjoy having the questions.
Okay.
And what the questions are designed to do is to alleviate whatever doubts or questions each judge has in his or her own mind.
Right.
And so this gives the attorney an opportunity to satisfy the judge that as to the questions that they have in their own mind.
So how would you advise an attorney to prepare for a Court of Appeals appearance?
Long and hard, and to anticipate what kind of questions that the court may ask. It's quite common in preparation for an argument before the Court of Appeals to have a moot court. And that would be to get either former judges or other associates or partners of that lawyer to grill him or her carefully as if it was the argument in court. And hopefully that would give the attorney an idea of what
reactions.
Yeah.
Now, just for the civics for everybody, I know because everybody knows the Supreme Court of the United States is the highest court, but the Court of Appeals in New York State, that's really because there is a Supreme Court, so it gets people who come here, they get mixed up. They think Supreme Court, yeah, I know Supreme Court, that's the highest, but not
in New York.
Right,
no,
it's the mid-level court, yeah.
Well, actually, it's a trial court.
And
it's the highest trial court. But you see, in terms of the relationship between the United States Supreme Court and the New York Court of Appeals, The United States Supreme Court will only be the highest court with respect to federal issues. If it's purely a state legal issue, the highest court and the final court would be the New York Court of Appeals.
So give us a few of the ideas of what would be, now, I don't know if it's typical, but certain cases that you have seen which would be like a state affected court case.
Well, any case, for example, interpreting either a New York statute passed by the New York State Legislature or a challenge under the state constitution, that would be the kind of case that the final arbiter of that issue would be the New York Court of Appeals.
Well,
one of your famous decisions that you wrote is David Griffin, the Matter versus David Griffin.
That is one of my,
Yeah.
I remember that case very well.
And that had to do with a policy which denied the inmate's family visitation privileges for his refusal to attend the only alcohol and drug treatment program. So it was something like, you know, we're not going to let your family visit you unless you do
go
this.
into the
Drug treatment program.
A drug treatment program which was basically based upon Alcoholics Anonymous.
Right.
And the case basically said that Alcoholics Anonymous has a very big dimension of religion in it.
Which I never knew.
And, well, it's the higher power.
They don't make you subscribe to any religion, but just like the judge has said, higher power. You have to believe in a God. There's a higher power to get you out of your dumps because you're an alcoholic. You can't lift yourself up from your bootstraps.
So people
if you're
who are
grounded.
So you basically people who are non-believers don't.
That's exactly what happened with Mr. Griffin.
I see.
He was an atheist and he didn't subscribe to higher power.
Can I tell you interesting? Now, Dr. Twersky, who's a rabbi, Dr. Twersky, is one of the biggest doctors, psychiatrists of alcoholism. So he came to Schenectady to JCC to talk. So I thought maybe he's a rabbi too, but he talked about alcoholism, not anything about rabbinics. And like you just said, you have to subscribe to a higher power or to an almighty.
Exactly.
So he was walking around afterwards the auditorium, and I had a question for him, and I asked him in front of a few people that we went with, that's all very fine and good. What if someone doesn't believe in a higher power? Then, your whole thesis goes away. He says, you know what? You know what I tell a person if they don't believe in God? I said, no, what? And he pointed and looked me straight in the eye. He was a small guy. You ever hear of these small guys that they make you feel like you're small. And he says, I tell them, oh, you do believe in God, but you think it's you. And he points a finger right at me. And then I saw him actually write it up in a book afterwards. But all right, so that's, I always remember that story because he was so pointed about that. Everybody thinks they're in charge of themselves in the world.
Well, there's a Twersky who is a very well-known and highly regarded law professor as well, and he is, I think he's of a Hasid.
Yeah, the Twersky family are all very.
Yes.
I wanted to, so getting back with David Griffin, I mean, so you ruled, I guess, on behalf of the court, not just you. Was it a 7-member court? Or,
it is.
Yeah.
Yep.
And they, saying that you couldn't have a carrot and stick approach, trading off
well, you
family
could have maybe a
visitations.
carrot. You could have a carrot, but not a stick.
Right, okay.
And the stick would be, you can't see your family unless you join this and subscribe to it. And that was a U.S. constitutional case, a First Amendment case, based upon the establishment clause of the First Amendment.
But it's still referred to today in other decisions, right?
It is.
Yeah.
It got a good play around the country.
Makes you feel good when you do
course.
something like that. So let me ask you, how does, if at all, I mean, your Judaism really impact one way or the other, in terms of your soul searching when you decide these cases or write about these cases?
Well, I don't think it has any direct influence on me, but of course, Judaism is, I guess one could say, a religion that is obsessed with justice. Mm-hmm. And of course, we had judges who ran the country during a period of time in our history. And you have the prophets who talk about justice all the time, how to be just, to do justice.
Mm-hmm.
So I guess that tradition, I think, even apart from the fact that both my parents were lawyers,
Mm-hmm.
that tradition has some influence in what you want to do with your life, I think.
Now, you mentioned your parents because there was a time your mother was an attorney, the time
Yes.
that really wasn't...
Very rare, very
Yeah.
rare, yeah.
So I heard that made you really proud that your mother could...
Oh,
really-
I talk about it all the time, and
Yeah.
also I'm very proud of the fact that one of my granddaughters just graduated law school and is waiting for the bar results. And so she is a fourth generation Levine lawyer and a third generation
Around New York
woman
here?
Uh-huh.
Levine lawyer.
She lives around.
No, she lives in New York City.
And what about the makeup of the court today is a lot different than when you sat on the court.
Yeah, there's nobody left that I sat with
Right.
who's on the court.
But there's like such a diversity in terms of ethnicity and religion. There's only one Jewish person on the Court of Appeals, Leslie Stein.
Oh, that's right. I
And then,
forgot.
and then you see, and then, but you have the first Muslim woman, first Muslim.
Well, I'm not
you know.
sure she's a Muslim.
What
I
is
don't
she?
know what her religion is.
No, that's that was
Sheila Abdul Salam.
Yeah.
Yeah, I don't know if she's
And-
a Muslim.
Well, when she was nominated, I mean,
Did it come out that she was
yeah.
Muslim? Well, isn't that interesting? I
And
didn't
it's
realize
not
that.
it's not a problem.
No, it's not a
just
problem
not
at all.
But I mean, that's just
she's
something.
a very good
that's,
judge.
That's all that matters, right?
Yeah.
But when you say
Exactly.
you had to quit, I mean, what is that age limit? Is there, because we're always
70,
talking about with the assembly, there should be term limits and age limits, for
Well, there
different
is
courts.
a constitutional age limit at the Court of Appeals.
Yes,
You can't serve beyond the end of the year in which you reach your 70th birthday.
Right. And for you,
I was just learning the job at that point.
and how old are you now?
I'm 84.
84.
Yes.
14 years went by, and you feel that you could have done just as well. You don't think there should be an age
That's what I
limit,
was going to
right?
ask. You think that it's...
I presume.
In a way,
because-
it's just because in Judaism, we're on the Jewish view, and my rabbinical view, there isn't an age limit. On the contrary, like I would think yourself, you're experienced, you know more, and just to cut you off and saying, sorry, you're not good enough, I don't know what they think 7 years old, you're not with it. What are they, the original intent of the law. But on the contrary, in Judaism, saying no, a person's more experienced, is more wise through time because.
Well, I'm going to
of age.
surprise you.
All right.
I think that 70 is too young, but there should be an age limit because that's the way you will get new blood coming into the court. If you stay on, when you think about what's going on with the United States Supreme Court, with 2 or 3 people are in their 80s at this point.
3, yeah.
And
I think it's just too old. They're not.
well,
feeble.
when you think about the fact that the law develops over time and meeting new challenges as it develops, there is something to say for the idea of getting younger people in with closer to what the reality of life is.
Right, not looking at it from
Yeah,
a day
from
gone by, a different generation.
Exactly.
Yeah.
So there's an advantage to getting that kind of changeover, which it shouldn't come by death.
Right.
It should come by perhaps well before death.
But you're probably earning more now than you did in all the years combined that you're.
Well, I don't think we should go into that.
Okay, we won't. But okay.
But the
I'm
answer
just
is-
teasing you.
You're a practicing attorney.
Yeah,
so
the
you
answer, of
keep
course,
on-
is that I was a public servant for
That's right.
the vast majority of my career
Right.
at the law.
So this is maybe a good
Yeah.
thing.
But now you're in private practice.
with Whiteman,
Yeah.
Osterman and Hanna, which is a top law firm.
And you keep fully active?
More or less, more or
Very
less.
good.
Yes, yeah. I
And
was
you-
very busy during the spring and early summer this year. Actually, I was working about 6 days a week.
What's your specialty in law?
I do mostly the kinds of things that retired judges do. arbitrations and mediations, and the other thing that has kept me very busy is that in a lot of international transactions, the underlying contract in the transactions has a choice of law clause in which it says that this contract will be interpreted and enforced in accordance with New York law. The reason why that happens so frequently is that in the commercial area, New York has always been the leader because of the fact that we're the state is the center of international commerce and communications and so forth and so on. And so the law has developed more in this state than in the vast majority of other states, and it's more certain and more predictable.
More and more people are mediating, you think, throughout your years?
Well, I was just explaining this particular role that I also perform, and that is when that contract gets in dispute, whether it's in Australia or the United Kingdom or Germany and so forth, and the contract has this New York choice of law clause, then the tribunal will entertain an expert opinion on New York law. And who knows more about New York law than a retired judge of the New York Court of Appeals? So I and my fellow retirees get retained by one side or the other to...
So even if they're international, they have nothing to do with New York State, they'll rely on New York State law?
They have to under the contract.
Really? That's interesting. Yes. I didn't know that.
So they get retained by one side or the other.
Exactly.
And you don't care which side, one way or the other? Or
well, I give them an honest view, and if it doesn't help them, they don't retain me.
Okay. So let me, now, you know, we hear that on the U.S. Supreme Court, Ruth Bader Ginsburg had a great friendship with Scalia, right? Judge Scalia. And, you know, they couldn't be more diverse in their opinions. What sort of camaraderie behind the scenes did you have? I mean, you're a Republican, you were nominated by a Democratic governor. Right. I mean, obviously, Mario Cuomo felt party affiliation didn't really matter. You had to be the right type of person, and the right common sense, and the right positions. What did you know, there were other Republicans. I think Judge Simons was on the bench when you were there. Yes. Saul Wachtler was on the bench.
No, Saul Wachtler had resigned.
He had resigned by the time you came on? Okay.
Actually, I came on as a result of his resignation.
Oh, okay, okay. Yeah. So, but there were Democrats on the bench. How did you get along with, I mean, is there a tight camaraderie? Or?
There was, and it didn't fall on, according to party affiliation at all. It's just people that you relate well to and who respect you.
So who'd you get along with?
I got along with everybody.
But what surprises can you know?
What surprises were there?
You know.
Well, I think the New York Court of Appeals traditionally has been a very collegial court, much more so than the United States Supreme Court. Historically, that's been the tradition. They say that when Cardozo went from the New York Court of Appeals to the U.S. Supreme Court, he really missed the collegiality that existed at the New York Court of Appeals, because at the Supreme Court in his day, McReynolds, who was on the court, was a flagrant anti-Semite. He wouldn't even speak to Cardozo. That wasn't very collegial.
Right, exactly. No.
What years are you talking about?
The 30s.
Yeah.
But it was very interesting.
Yeah. And then, you know, I was looking back at the past judges on the Court of Appeals, and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 were Jewish in all the history of the New York Court of Appeals.
Oh, I think even more than that, I would suspect.
Charles Breitel, Ben Cardozo, Jacob Fuchsberg, Stanley Fold, Judith Kay, Irving Lehman, Jonathan Lippman, Sam Rabin.
Oh, Samuel Rabin, yeah.
Rabin, Albert Rosenblatt,
right.
Leslie Stein, and Saul Wachtler. I couldn't find any other
Well, yeah, you
that
got
were
me.
Jewish. So I'm just saying, people think, oh, Jewish and judges and attorneys and all, but here in the highest court and all, what is it, over about 200 years that the court is?
1846.
Okay.
1846. Yeah.
So
In the
it's-
1800s, you probably wouldn't have too many.
So it's 150 years, let's say, and, you have only 11 judges who were Jewish. I mean, I just find that fascinating.
Well,
Just-
I don't know how many judges that would amount to. It might not be all that much. I'm sure.
I went on the web, they have
Yeah.
this historical background that people write up.
Yes,
Oh,
yes.
with yours, you had someone that you
Well,
chose to write.
I sat with Al Rosenblatt.
Yeah.
And Judith Kay.
Right.
And who else? Who was then Jewish? Well, that was 3 out of 7.
Right. Which was, who else was on, I said Simons was on the court.
Right.
And who else was on the court?
Bellicosa, Joe
Bellicosa.
Bellicosa was on the court. Carmen Saparic was on the court.
Right.
Who else?
Well, that's 6, so.
Yes,
that's
whatever,
okay.
right.
So, so there was, now I got to tell you, I was very surprised when I read that Irving Lehman was chief judge from 39 to 45, or he was on the court from 39 to 45.
Oh, no, he was on the court longer than that.
Oh, okay,
Yeah.
then he was chief judge from 39 to 45, and his brother was Governor Herbert Lehman.
That's correct.
And they serve, here's the 2 brothers, governor and in the executive and judicial branches, and there was a lot of concern.
There was concern at that time.
Yeah.
There was some concern, but he was a very fine judge with an excellent reputation, only second to Cardozo himself, the great Cardozo.
Mm-hmm.
And there were occasions when the governor might not have liked one or more of his rulings.
But also, it was said that when when Governor Lehman's wife couldn't be around as hostess, Irving Lehman's wife filled in as
On
first
occasion,
lady.
yeah, that's right.
Which I thought was kind of interesting. You go back on this history. I just, these notes, people just don't realize these little tidbits. So that's why I ask you: are there other little, tidbits or little stories that you have that are unique that you might want to share? Or
I can't.
because you make it sound like it's so dull and boring.
Oh no, it's very exciting.
It's exciting. Okay. So the other ruling that you gave, which was fascinating, was the decision upholding the Rockefeller drug laws.
On the sentencing, the mandatory sentencing. I didn't like them at all, but it was a legislative prerogative, and to my mind, it was very clearly constitutional. And the court, I think we had 1 or 2 dissents on that, but a majority of the court agreed with me.
So, now we see the Rockefeller drug laws, the harsh sentences and penalties are changing.
Well, I think the whole attitude of the public toward crime in general and drugs in particular has changed for the better, for the better.
Okay.
A more individualized system of criminal justice.
Can you talk about the prudent investor rule?
Can I talk about it? It's a good rule.
Okay, but the details about it.
It's a rule and there has to be a rule, of course, if you entrust your money to someone else.
Yeah.
In a trust or by reason of your will, setting up a trust, and particularly if you use an institutional trustee like a bank, there has to be a rule that you're putting money into that bank's hands, and the bank gets an income from it, a fee for that, and so there has to be a rule that like negligence or malpractice with respect to putting your life in the hands of a doctor, there has to be a standard of care in handling that money and investing it prudently.
And there was a case with Kodak stock that
That's
you
right.
ruled about. Yeah.
I did. And what happened there is a bank in Rochester, of course, brought up on the idea that Kodak was the best investment in the world, obviously. It was a local, like General Electric in Schenectady, and that it would never go down in value. Well, it did. And one of the aspects of the prudent investment rule is diversification. We all know now, I think, that the way to invest is not to put all your money, all eggs in one basket,
Right.
and to diversify equities.
So what does the law say? I mean, obviously that's good, business, what you're saying, but meaning it would be against the law for a firm to say, okay, one stock is good, and we're just putting all your money into one stock?
That would not satisfy the prudent investment.
Yeah.
It says here, a trustee may not insulate himself from liability for one imprudent investment by forcing the beneficiary to accept or reject his investments as a whole.
That's certainly part of it.
Okay.
That's right. And
The principles that diversification does not absolve the trustee from liability for an imprudent investment has remained an important principle of New York law.
that is definitely makes very good sense to me.
But that's what you wrote. That's what,
Exactly.
Okay. So that's why I'm.
Well, you've done your homework.
I love this stuff. I love this stuff.
Oh, I thought you thought it was boring.
No, I said you make it sound like the people in the court that they don't. I mean, I thought you'd say, oh, we go and play cards, we have fun, we go out and we socialize, we, have some, we're just not in.
Well, part of the tradition, which because I came, my home is in this area, but apart from that, one of the traditions was that the court, when it's in session, all the judges go out and eat dinner together and don't discuss anything about the cases during that period of time, of course, because they're in a restaurant and they can't discuss. It might be overheard discussing the cases. So that's a time when you can socialize and talk about the weather or talk about sports or whatever, tell jokes.
Yeah. Well, that's what I was.
And that adds to the collegiality of the court.
Now, your daughter, okay, yeah, your daughter Ruth passed away.
She
right?
did,
Okay,
yes.
from breast cancer.
Correct.
And October is Breast Cancer Awareness Month.
It's always Awareness Month for me.
Yeah, so can you talk about that a little bit? Because no parent should ever outlive a child. But.
No, it's certainly the greatest tragedy of my life.
Yeah.
And I still think of her all the time. She had a great legal career that was flowering when she got sick. She she had been an assistant DA in Morgenthau's office, the New York County DA's office. And from there she went to becoming a criminal court judge appointed by someone who remains in the news. Mayor Giuliani appointed her. And she blossomed in her judicial career to the extent that Chief Judge Kaye created a very progressive idea of dealing with the problems people have with the courts, the number of courts in the New York court system. And she addressed the problem of, in a case of domestic violence, for example, if the husband and wife want to get a divorce, they have to go to Supreme Court. If the wife wants to make a criminal complaint as a result of that domestic violence, she has to go to a criminal court. If she wants an order of protection and wants to get sole custody of their children, she has to go to family court. So Judge Kaye's idea was to create in one judge all of those various roles. And she started sort of pilot programs, one in New York City, and my daughter was that judge with all the 3 or 4 different hats.
Oh, wow.
Yes, that's right.
And she made a success out of it, and it was replicated around the state.
Wow. So, well,
So she had a great career.
And-
And there is the courtroom in the Bronx where she sat has been named in her memory.
wow. That's special. That
Yes.
is. And her husband, David Sussman, do you still stay in touch?
I'm just like my own.
Just like your own.
Yes,
And he's Executive Vice President, General Counsel for MTV Networks.
he was.
Was, not
Yes,
anymore.
Not anymore, right.
Because I was wondering if you got into MTV because of that.
No, but before...
You don't seem like an MTV guy.
No. But Sumner Redstone, of course, was the owner of MTV,
Right.
and characteristically of Sumner Redstone, you don't stay in his employ forever.
Okay. Now, your initials,
Oh.
Howard A. Levine,
Yeah.
Hal.
Yeah.
So tell us what that nickname, what that acronym
Well,
became to a
I think it
nickname.
was my law clerks who, unbeknownst to me, called me Hal.
Okay.
And when I retired, there was a retirement dinner, and they put on a skit roasting me. and it was, the title of it was Our Pal Hal.
Our pal Hal. Okay, well, you know, Hal is also the name of the computer in Space Odyssey.
That's right, I hadn't thought about
2001:
that.
A Space Odyssey.
I hadn't thought about that.
And HAL is one letter off from IBM, HIABLM. And that's
Wow.
Where it comes up with some
And when
real
they
stuff.
used HAL, the computer, it was really an IBM computer. It was named, but that's how they named HAL.
That's how they got to it?
Yeah.
Well, it was the beginning, it sounded a little Talmudic to me, as you explained it,
No. So I just wanted to let you know that you have
Okay.
something in common with that.
with a
too. So-
computer. Thank you very much.
Judge, we're out of time. It was really enlightening, and I'm glad that you came on the show.
And
keep
I'm
on
very
with-
glad, and I've enjoyed it. Thank you very
Well,
much.
you're very
Keep
welcome.
going with good health.
Yes.
Thank you, you too.
That's
That's what we need.